You may file a divorce petition now. The husband and the wife may just come to court and say, I want some of this property to be settled on me. The court will consider her claim. The court will not shut her off. The court will consider her claim. It is not left for her to prove. So the court will. Hello, welcome to my channel, beautiful people. My name is Mary. I'm a legal practitioner and a real estate consultant. Thank you so much for joining me on my YouTube channel. If you're a new subscriber, thank you so much for being a subscriber. And if you're a returning subscriber, thank you for coming back to watch my video. In today's video, I'll be discussing a particular topic, settlement of property in event of divorce. I received a lot of messages on this particular topic where people will ask me, in the event of divorce, will my property be divided between me and my spouse? A lot of questions. In the event of a void marriage, if I contracted a void marriage, if what is between me and my partner is a void marriage, will I need to divide my property? Will my property be divided between me and her? A lot of questions that borders on divorce, settlement of property. And I've been able to highlight 5 questions, and in those five questions, I think 4 questions, I will be answering each of those questions based on the statutory authority and also judicial authority. So please, one of the questions is whether property jointly or separately acquired will be considered for settlement between parties in the event of divorce. That is number 1. Number 2, whether a party can claim settlement of his or her property, of his or her partner's property, when there are no children as a product of the marriage. Number 3, whether a party to a void marriage can make an application for settlement of property in his or her favor. Number 4, whether personal property such as shares, electronics, furniture will be considered in settlement of property. Before I continue, please, I would like to mention that whatsoever I say in this video should not be construed as legal advice. If you need a legal advice, you need to consult your lawyer. Your lawyer will be in the best position to guide you, to give you legal advice. So please, this video is solely for educational purposes. And also, this video is for people that contracted marriage under the Act. What people refer to as court marriage, that's registry marriage. This video is only for people that contracted the marriage under the Marriage Act. And also, there are some people that they did not, their marriage was not in the marriage registry, the court, it wasn't there, it was just in the church. So you need to know if your marriage, if the church you contracted, you had your celebration of marriage, is a licensed place of worship. So you need to check your certificate, because there are some people that contracted the marriage in the church, and the church is a licensed place of worship, which means their marriage is also under the Marriage Act. So you need to check your certificate or go and meet the elders or the leader, the pastor in the church, to confirm if your marriage, if you were given a certificate under the Marriage Act. So this video is solely for those people, not for people that just did traditional wedding. Okay, so, and also in this video I'll be mentioning certain terms like parties. So when I say parties, I mean the husband and the wife. So in discussing these questions, I will not be answering the question, because if I say a thing based on this question, if I answer this question, you may proceed to court and the court will find another opinion or another ruling. So I will just be discussing those 4 questions. I won't be answering them. I will be discussing them based on the provision of the law. So my first provision of the law will be Section 72 of the Matrimonial Causes Act. The Matrimonial Causes Act is the law that governs dissolution of marriage in Nigeria. So basically, Section 72 of the Matrimonial Causes Act, I will implore us to actually take note of certain the wordings of the law. So the court may, not shall, the court may, possibility, may, in proceedings under the Act, require the parties to the marriage, that is, the husband and the wife, or either of them, to make, for the benefit of all or any of the parties to, and the children of the marriage, such a settlement of property to which the parties are, or either of them is entitled, whether in possession, that is, the property that you currently own, that you currently have in your name, or reversion, Reversion property, let me just give an example. For instance, if Mr. Adeleke transfer a plot of land or a house to his cousin for the cousin to use for his lifetime. So once when the cousin died, the property will come back. So that is reversion to Mr. Adeleke. So that kind of a property is also part the definition. This provision of the law also covers that kind of property. So whether in possession or reversion, as the court may consider just and equitable in the circumstance of the case. So the word just and equitable means something that is fair. So that's the provision of that law. So if let me just try and interpret that. Yes. So basically, this particular provision of the law is saying the court may. That is, there is a possibility that the court will consider property that are jointly or separately owned by the parties and give let me say an order or instructions or a ruling that such property that are jointly or separately owned should be settled for the benefit of probably the wife or the husband or the children. So I think when later in this video you get to understand that better with the judicial authorities that I will be providing. Also, there is also a subsection to that. The court may consider the proceeding under this act, under the act, make such order as the court consider just and equitable. That is, the court's the definition of just and equitable will mean something that is fair. Yes, FAIR, something that is fair, something the court will use its discretion to check what is fair, what is equitable to do in this in each case. So that is that for the statutory authority. Now to the judicial authority, I have the case of Honourable and Honourable. It's a 2005 decision where the courts held that a person who claimed to be the joint owner of a property must be able to quantify his contribution. He must give detailed particulars and support them when necessary with the receipt of what he brought towards the building. So this Honourable and Honourable, this particular case, I think the wife made a claim. She laid a claim that she wants some of the property of the husband to be settled on her, and her claim, the evidence she gave was just that she supported the husband when the husband was building the house and all sorts. So the judge in this case is trying to say that the wife only made a claim and she left it there, that she didn't support it with enough evidence. So the point here is putting section 72 of the Matrimonial Causes Act and this provision of the law, this Honourable and Honourable means you can come and say, I want some of my husband's property to be settled on me, but your claim will not be enough. You need to bring evidence, probably receipts, or probably, okay, I bought some bag of cement, or it may not be financial support, it could be non-financial support. So you just need to come, after making your claim, you must prove your claim if you want some of the property to be settled on you. Also, I have another case of Ebetu, Etsebu, and Etebu. It's a 2018 Court of Appeal decision. I'm sorry if I did not pronounce that name well. Basically, in that case, the wife also came and she laid a complaint that she wants some of a claim rather, that she wants some of the husband's property to be settled on her. So the husband defense was that the marriage is a void marriage. Basically, a void marriage means a marriage that does not have any legal consequences. That is, a marriage that never happened. For instance of a void marriage, I think I have a video of a void marriage, but it's not that comprehensive. I think I have it on my channel. So, a void marriage, example of a void marriage, let's assume Mrs. Bingbe was married to Mr. Korede in 2010, and about maybe 2012, Mrs. Bingbe was not so happy with the marriage as she left the marriage to marry another man. The marriage between her and that Mr. Korede, she's yet to dissolve the marriage. She needs to proceed to a court. That is, if I'm talking about, I'm laying this scenario that she contracted a marriage under the act. So the fact that she did not divorce the man, there was no dissolution of the marriage, and she went to marry another man, that second marriage is void ab initio. That is bigamy. It is not possible. So that second marriage is void. So in that a table and a table, the husband defense was that the marriage was void ab initio. So the court in his wisdom said the fact that marriage is void ab initio is not enough for the woman not to lay claim or for property to be settled on her, because what the courts we consider is the fact that two people has actually come together to acquire something or to build something. Just like me and my partner coming together, me and my friends coming together to actually acquire a plot of land and build it together. So that is what the courts will be looking into, not whether the marriage is valid or not valid. So there are lots of decisions on this settlement of property. So now with this judicial and statutory authority, now I want to discuss each of the questions, each of the 4 questions I read earlier. In answering or in discussing this question now, whether property jointly or separately acquired will be considered for settlement between parties in the event of divorce, yes. It will be considered doesn't mean it will be divided or it will be shared. So that is what I just want you to understand, because the wordings of the provision of the law, the courts made. The wife can come, you may file a divorce petition now, the husband, and the wife may just come to court and say, I want some of this property to be settled on me. The court will consider her claim. The court will not shut her off. The court will consider her claim. It is not left for her to prove. So the court will consider it. Does not mean the court will definitely, or the court is under compulsion to settle the property on her. So that is what I just want you, my audience, to understand, that the court may consider such property. The court will do what is just and fair, depending on the claim, the proof from the one who is claiming settlement. So if his or her evidence, they are weighty, if it's good enough, the court will do what is just and fair. So number 2, whether a party can claim settlement of his or her partner's property when there are no children as a product of the marriage. The fact that there is a child or children does not matter. What you will be telling the court is maintenance. If you contributed, if based on your claim and your evidence, if you contributed financially or morally while your partner was building a house or buying a car, and you want that property to be settled on you, you just need to prove it. The issue of whether you have a child or you don't have a child will not show up in this instance. So you can always lay your claim of maintenance. It is left for you to prove to court why you're laying that claim. You need to bring receipts, you need to bring things that you know, okay, they will be of a good proof that you indeed contributed to the acquisition of that property. Number 3, whether a party of a void marriage can make an application for settlement of property in his or her favor. I think the case of Odedele and Odedele 2018 Court of Appeal decision, I think that covers that. The fact that your marriage is void ab initio will not, that is not enough for you not to make your claim. You can go to the court and make your claim, even whether your marriage is valid or not valid. So you can make your claim, because what the court will check at that instance is not the validity of the marriage, but to actually claim what belongs to you, if truly you contributed to the acquisition of that property. Number 4, whether property such as shares, electronics, furniture, etc. can be or will be considered in settlement of property in the event of divorce. Yes, both personal property and real property. Personal property are those movable things, and it could be tangible and intangible. Tangible like the furniture, the electronics, and intangible like shares. Yeah, and real property, the movable one, land, all those ones, everything will be considered. The only thing is the court may remember and will always do what is just and equitable. What is just and equitable will depend on the proof of he who laid the claim of, I want some of this property to be settled on me. As a sort of conclusion, if you're watching this video, you intend to file a divorce or you already filed a divorce, please do not panic thinking, oh my God, everything I have worked for is about to be divided. No. If the other party cannot prove the claim, yes, if he or she cannot prove the claim, please be rest assured that the court will always do what is just and equitable. If that person cannot prove the claim, the court will not grant the person's wish or the person's claim. So please do not panic. All you need to do is to consult your lawyer and provide necessary information and necessary documents and necessary things that you know it will help the case. And I know definitely your lawyer will do a good job. And also in another video, I will be sharing validity. I will be sharing a video validity on pre and post nuptial agreements. You know, in situation like this, whether you want your property to be settled or not in event of divorce and all that. So some people do have agreements, yes, between the couple to talk about the finances, and in event of divorce how it will be settled and all that. So see you guys in my next video. Please do not forget to like this video if it educates you, and also share with people that this video will educate and assist in one way or the other. Thank you so much for watching. See you in my next video.